A Supreme Court ruling is cutting the EPA's Clean Water Act protection for wetlands, and that's sending chills down the backs of environmental advocates. The High Court ruled against the agency in a long-running dispute with Idaho landowners known as Sackett versus the EPA.
As News 4 Investigates discovered, while this decision could significantly reduce the number of wetlands that are protected, it also provides property owners with more clarity. Luke Moretti reports.
It doesn't throw out the Clean Water Act.
Steve Ammerman is the director of communications for the New York Farm Bureau. He says the Supreme Court ruling doesn't give free rein to pollute, but does provide more clarity.
What we were more concerned about was the middle of the farm fields that were dry, the road ditches, things like that. So I think that was the concern of farmers, at least, of how that affects agricultural land that could be miles away from any navigable water.
Environmental advocates fear the decision will likely have a negative impact on the Great Lakes and local waterways. Margot Valenti is the legal director for Buffalo Niagara Waterkeeper.
The court's decision to deregulate wetlands will hurt everyone in the United States. It's going to remove protections for millions of acres of wetlands.
The Clean Water Act of 1972 allows the government to set rules for pollution in waters of the United States. There's been heated debate for years over what that phrase actually means.
It was changed under the Obama administration. There's a lot of debate. President Trump changed the rule. The new Biden rule came into effect. And the initial rule under the Obama administration greatly expanded the definition of waters of the United States.
The nation's high court ruled that the Clean Water Act covers wetlands with a continuous surface connection to a traditional navigable waterway. But as an ecological matter, Margot Valenti of Buffalo Niagara Waterkeeper calls the opinion wholly nonsense.
It discounts the fact that groundwater connections exist. It doesn't account for the fact that wetlands are sometimes dry, and some of our most important wetlands in Western New York fit those criteria.
From the EPA's perspective, the definition of the waters of the United States included all waters that could affect interstate or foreign commerce, even adjacent wetlands without common borders or direct surface connections. Critics, including farmers, argued the EPA's interpretation violated property rights and required impractical and expensive fixes.
Under the Obama administration, it greatly expanded that to include, by some estimates, more than 90% of the land in this country. It could include road ditches. It could have included wet spots following a rainstorm in a farm field. It was really very subjective.
But Valenti says the Supreme Court had already exempted ditches.
With regard to the agricultural concerns, I think many of those statements are misleading and misguided. There are plenty of exemptions to protect our agricultural industry.
Even 4 justices in their concurring opinion stated that by narrowing the Clean Water Act's coverage of wetlands to only those that have surface connections with navigable waters will leave some long-regulated adjacent wetlands no longer covered by the law.
It enables just what you can see with your eye to be the only thing that is protectable, and that just does not make scientific sense. It's not based on sound science.
Our farmers, they need clean water. They want clean water. They've taken extreme measures over the years to greatly increase the number of cover crops, environmental management programs, buffer strips and terracing, things like that to reduce erosion.
This effort to adopt a clear standard by the nation's high court probably will not be the final word in this complex and at times confusing area. There's sure to be more ambiguity surrounding wetlands regulations and the scope of the law in the future. Luke Moretti, News 4.